This morning on the Ag Issues program, a pleasure as always to bring on to the program, as we have for many years, every couple of weeks, Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the Ag Issues program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, let's get right to it. This first case is from right here in the state of Kansas, and it talked about that the debtors lacked reasonable likelihood of putting together a retooled Chapter 12 bankruptcy plan.
Yeah, that's right, Greg. And just to kind of preface everything that we're going to talk about, farmers and ranchers face numerous legal issues on a regular basis. And that variety, I think people are going to hear again today, is vast, from contract issues to income tax issues, estate and business planning, real estate related issues. You've got other issues that come up from time to time with water and criminal matters and environmental law, and then you've got frequent issues with federal and state administrative agencies. But in this first one, as you mentioned, we're dealing with Chapter 12 bankruptcy, and that is a specific chapter of the bankruptcy code just for family farmers. You have to meet that definition of qualifying for Chapter 12 by being a family farmer. And this was the genesis of this was from the farm crisis in the 1980s, and it's designed to keep family farmers on the farm continuing to produce food and fiber. And the way we do that is to perhaps sell off some assets, downsize a bit, and restructure those debts. Well, you've got to put a reorganization plan together. You've got to show the court, show the bankruptcy trustee, here's my plan as to how I'm going to get out of the hole that I'm in and stay farming. And that's what happened. This is a Kansas case, as you mentioned, and they did put a Chapter 12 reorganization plan together. It got confirmed in early 2022 by the court, but then they soon had trouble making their payments under the plan. And they first managed to make an annual payment to a bank, which was one of their creditors, but they couldn't do so starting the second year. And so the trustee filed a motion to dismiss the case in late 2023, and then you had another creditor that came in and filed a motion for relief from the automatic stay. They said, court, lift that stay. We want to be able to pursue collateral of the debtor and liquidate that. And, of course, the farm debtors didn't want to do that. They wanted to reimpose the automatic stay to get more time so they could modify their Chapter 12 plan and make payments to a creditor to avoid for having their farm foreclosed on. And ultimately, they did not prevail on that because the court determined that they just weren't going to be able to do it. They were trying to say, we need more time to secure financing and sell some assets off. But the court looked at this and said, well, really, you have little likelihood of success in modifying your plan in a manner that's going to allow you to make planned payments. And the court's going to look at a whole bunch of things to make that determination. The farm economy, your off-farm income, your crop production, what's going on in prices of the commodities that you sell. And so the court just said, look, and the judges, the bankruptcy judges, farm bankruptcy judges in Kansas, the ones that handle the farm cases, are actually pretty pro-debtor. They will bend over backwards many times to help farmers when they can. And here you had a situation where the court tried, I think, its best, that they said you just can't do it. And so this case got voluntarily, the court directed the farmers to either voluntarily dismiss this adversary proceeding or provide reasons why it shouldn't be dismissed. So it's going to be a tough road for these folks. They had to show cause within 14 days of the court's order, or else the court was going to dismiss the case. So it's a rough one, but we are seeing some more of that, an increased level of stress in the farm economy. This is just one of the recent Kansas farm bankruptcy cases.
There we go. Let's move on to the next case, and this has to do with the Fair Credit Reporting Act waives sovereign immunity, but Roger, this is a pretty important case.
This is a really important case, Greg, because it involved, one, and not only did it involve the USDA, but it involves an important principle of being able to sue the federal government to recover damages. Normally, you can't do that. People have probably heard the term sovereign immunity, that the government is sovereign. You can't sue them for redress for damages that they cause you. But there's an exception to that, and that is when the Congress has specifically waived sovereign immunity in the applicable statute governing that administrative agency. And that's what you had here. You had a person that got a loan from a division of the U.S. Department of Agriculture. It was the Rural Development Housing Service. So that's USDA. And they repaid it in full by the middle of 2018. But the USDA repeatedly informed the Consumer Credit Reporting Company that their account was past due. And so their credit score was damaged and their ability to secure future loans at affordable rates was threatened. Well, the borrower here, the previous borrower, notified the company of the error, and the company in turn notifies the USDA, but the USDA didn't correct its records. And so finally, the individual threw up their hands and filed a lawsuit against USDA saying you were either negligent or willful in violating the Fair Credit Reporting Act. And the USDA said, well, you can't sue us. We're the big bad government. We're going to motion to dismiss this case based on sovereign immunity. And the trial court agreed and dismissed the case. And it eventually reaches the U.S. Supreme Court. And they took the case up because there's this distinction between circuit courts. The Third, the Seventh, and the D.C. circuits have held that the Fair Credit Reporting Act authorizes suits against the government agencies, and the Fourth and Ninth Circuit said, no, it doesn't. Sovereign immunity applies. And so the Supreme Court looked at this, and they said, the statute that creates the Fair Credit Reporting Act did make a clear legislative statement about Congress waiving immunity of the government in this instance. And the court issued a unanimous 9-0 opinion determining that the Fair Credit Reporting Act clearly waives sovereign immunity by applying its provisions to persons who furnish information to consumer reporting agencies, and that the term person includes the federal government. So that's a big deal. There are a lot of these loans out there, and as the court pointed out, the government is a primary lender to a high percentage of these loans to individuals that are covered by the Fair Credit Reporting Act. So this gives redress to people that have been disaffected by the government's either willful or negligent failure to report things properly to these consumer reporting agencies. So that's a really important case, and it was a unanimous decision, as I said, by the Supreme Court.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us on the program this morning. Roger, this next case, has to do with deed languages, and in this case, it was no fee, simple, determinable, created without specific deed language.
Yeah, that's right. This involves a case coming out of a small town in the Flint Hills here in Kansas, and the city got sued over ownership of a couple of tracts of land that were deeded to the Kansas Highway Commission in 1970 and 1972 for highway purposes. And those deeds said that they transferred what's known as fee simple rights to the tracts, to the commission, with retained interests in oil, gas, and mineral rights. Now, fee simple is the largest form of ownership possible, of potentially infinite duration. So there's no carve-outs with respect to that. You own the property, you own it outright, potentially infinite duration. If you live forever, you own all of the rights in that property. So there was nothing reserved. Well, the city annexed all of K-273 adjacent to those tracts, and the Secretary of Transportation removed that highway from the state highway system, and so it reverts back to local control. Well, later that year, in 2002, the state issued a quitclaim deed to the city for various tracts of land, explicitly referencing those 1970 and 1972 tracts. So a quitclaim deed just says, whatever interest I own in the property, I give to you. If I don't own anything, you don't get anything. If whatever I own, you're going to get. And so you're not making any warranties or other representations concerning your ownership. It's just whatever I've got, I'm going to give it to you, and I may not have anything. So the deed said it was receiving, or that well, let me back up here. What happened in the next year, the plaintiff in this case bought the balance of the property from the successors to the grantees of the 70 and 72 tracts. And it said he was receiving the land that used to belong to the grantors of those deeded tracts, except for the land deeded for highway purposes. Well, long story short, you get in a dispute over the fact that the highway is not being used anymore. And so he's claiming, well, that was a fee simple determinable because there was a specific use that was mentioned, and that usage is no longer there, so I should own the property. Long story short is that no, back in 1982, the Kansas Supreme Court said that just the Kansas law says that the mere expression that property is to be used for a particular purpose is not enough by itself to turn a fee simple into a fee simple determinable. And so without that language specifically saying that there was a reservation for a specific use, and just the statement of being used for highway purposes was not enough. And so the original deed's language that lacked any reference to a reversionary interest is what was the key here, not what happened later on. And so that was that's an important point for people to understand. Anytime you're buying and selling real estate, make sure you have a trained professional that examines that granting clause carefully for you so you know exactly what interest you're acquiring.
As we move on, Roger, this has to do with farm leases, and at the issue with this case is the interpretation of the farm lease.
That's right, Greg. This is a Kansas case from Northwest Kansas, and this is a cash farm lease that was entered into for the calendar year 2020, and it was in writing, and that's the key point here. So if you have a written lease, the terms of the written lease are going to control. And the lease said that the tenant was allowed to harvest any wheat crop that he planted in the fall of 2020 by the following summer. And it also said that crops planted during the term of the lease were to be planted on a rotational basis rather than in a continuous crop fashion, unless they had enough moisture in that area and the landlord consented to that. Well, the lease renewed for 2021, and then notice to terminate was given on August 27, 2021. So you got a one-year lease tied to the calendar year. Notice is not given to terminate. It's going to renew for another calendar year. So it did. Now the tenant gets notice to terminate on August 27, 2021. At that point in time, he hasn't planted any wheat. So the ownership of the lease ground then changes hands, and the tenant notified the new landlord of the tenant's intent to plant wheat on the irrigated ground. Now remember, he's already gotten notice that the lease is going to terminate. The prior owner informed the tenant that planting wheat was not permitted. He said, look, I already told you, I terminated you, you can't plant wheat this fall. And the new owner did the same thing a few days later. Well, in October, and that was in September, in October, he harvested corn on the irrigated ground while it was still high moisture corn, which was unusual. That's not normally what he had done in the past. And he paid the lease obligation through the end of 21 and then paid the balance of that on June 22nd of 2022. Well, he stays on the property. And the new landlord sues for breach of contract and unjust enrichment, and the courts agreed with the new owner. And the lease provisions that did make a distinction between wheat ground and irrigated ground, they said, look, the tenant's interpretation of this would have resulted in an unintended windfall if we interpret that in a way that allows him to continue to plant continuous crops on the irrigated ground. And the buyer of the lease land had the right to enforce the terms of the contract. So a couple of points here, Greg. One is if you have a written lease, follow the terms of the written lease. If you know when it's going to terminate, and here you got actual notice, before you plant the ground, you're not going to be able to get that crop. And then secondly, when the land changes hands, the new owner takes subject to any existing lease. I see that get confused all the time. And so the new owner has the right to terminate the tenant in that situation. Now, what we had was the previous owner giving notice and the subsequent owner giving notice, both before the individual planted that ground. And so the tenant's going to lose that case, and he did so.
And the last case we want to discuss comes from the state of Oklahoma, and if you ever had tort claims, specifically in a case. In this case, though, it is a cattle ranch's lawsuit against an energy company for a pipeline leak revived.
Yeah, the court kept this case alive. It's going to go to trial. But what you had was, as you said, an Oklahoma cattle ranch, and their workers noticed a diesel fuel odor coming from a cave. And so the ranch hired experts to test the soil and surface water and the groundwater for possible contamination by hydrocarbons. And the test found trace amounts of refined petroleum products. And they couldn't get this thing settled, so the ranch sues the energy company in late 2019 with a bunch of tort-related claims: negligence per se, trespass, unjust enrichment, private nuisance, public nuisance, the whole lot. And the company moved for summary judgment on the basis that its pipeline that carried gasoline and diesel fuel beneath the ranch was not leaking, and that the ranch failed to show any injury from just the small presence of hydrocarbons. The trial court looked at this, and they lumped all of the tort claims together, which required a minimum level of contamination to be present to establish injury, and ultimately granted summary judgment to the energy company. Well, it goes on appeal to the U.S. Court of Appeals for the 10th Circuit, which Kansas is a part of, by the way. And the court said, look, we've got different types of proof standards. We have different types of legal standards that apply with respect to each of these tort claims. And it wasn't proper for that trial court to lump everything together. So they're going to piece this apart to see if there's sufficient evidence. Back at the trial court, the 10th Circuit said, you've got to look at this on a tort claim by tort claim basis to see if there's sufficient evidence for each of those claims. We can put the nuisance claims together, but then you've got to separate out these other types of claims. And so this case will go forward to see if there's enough evidence to show if the energy company had, for example, the intent to commit a trespass, or knew that its pipeline was leaking, or overlooked the leak and failed to tell the ranch about the leak in the pipeline. So we'll keep an eye on this case, Greg, because it's going to go back to the trial court. They're going to have a trial on these issues, and it should be instructive in terms of what evidence a rancher or other landowner would need if there's an underground leaking pipeline that causes damages.
And Roger, if people want to look more into these cases, they obviously can go to your blog.
They can momentarily. I'll have it up in just a few moments, and then we'll also share that with K-State so that it can be posted on the Ag Manager website.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.